See the continuation, Article 27. Article 27 lays down that no person shall be compelled to pay taxes for the promotion, maintenance of a particular religion, otherwise the religious demonstration. In other words, the state shall not spend public money for any way of the by way of the tax for the promotion and maintenance of a particular religion. This provision prohibits that imposing the levy and not fees. Means, if you remember, during the war period, Kargil war, we paid the tax and 3% cess we have paid. The tax was collected, used for the sake of the tax war purpose. Here also, if any tax can be collected for the religious promotion purpose, Constitution prohibited. Government cannot collect any tax for the promotion of any religion. However, fees can be collected. What does it mean? If you go for darshan, they can charge the amount. Shighra darshan, pay 1,000 rupees or 5,000 rupees, 10,000 rupees, or 300 rupees or 100 rupees. Everything is available there. Fees can be collected, but government cannot impose any tax. Like a additional, you are paying the GST, no? That like the tax cannot be collected for the promotion of the religious purpose. Next one is Article 28. No religion instructions shall be provided for any educational institution wholly maintained by out of the state funds. However, this provision shall not apply to the educational institutions administered by the state, established under the endowment or the trust requiring the imparting the religious institutions, such institution. Means, what exactly it means here? Government means central government or state government cannot provide any kind of a religious preachings where there is a government money involved. For example, government schools are there, government junior colleges are there, government degree colleges are there, universities owned by government is there, government is spending the money. There you cannot preach any religion. If any institution came into force out of your own money, Endowment Act is there, then endowment is spending some money for a particular purpose, like a minority institutions are there, you can spend and you can use for that. They can preach. Go to the missionary schools are there, prayer is compulsory, you have to believe the Jesus. But whereas no Hindu school say that you believe only in Hindu. There are some institutions where they can preach because that is purely run by private penny. There is no public money involved. Public money was not there. Government is not giving a single pie. They are collecting the fees from the parents, paying to the teachers, managing the schools and colleges and those universities. Minority institutions, missionary institutions were there. Government funding was not there. If a government is giving any aid, granting aids are there, they cannot preach any religion. That is 28. Now 29. Any section of the citizens residing in the territory of India or part thereof having a distinct language, script, culture of its own have a right to conserve the same. Nothing but our language, Telugu. I think over a period of time, the Telugu people won't speak. Already people stop speaking in Telugu. People speak only in Hindi, English. They feel privileged. See, being a Tamilian, he speak only in Tamil. That culture. When the vernacular language is there, that language, when you read the literature, better you understand. Whereas Western influence is there more on us, especially Telugu people. I am not generalizing everyone, especially Telugu people. They feel that if they speak in Telugu, below their status, below their dignity. And they are forgetting that Telugu you can communicate in a best way, where everybody can understand. Even you speak in English, majority may understand, 98% may understand, but there are 2% where people cannot understand totality. But speaking your language, your culture has to be promoted, isn't it? Your language, nothing but Telugu, it has to be protected. Many people, if you remember, former president, Vice President Venkaiah Naidu always say, speak in Telugu, protect the Telugu. And he is always giving some kind of orientation. Elder people are there. And people will speak, and we have to respect that. And wherever necessary, speak in Telugu, yeah, nothing wrong in that. When it requires, you have to use the other languages, nothing wrong in that. People can't understand, then we have to use that language. Where people can understand, better you can speak in Telugu. When two people, Telugu people meet, they speak in English. When two Tamilians meet, they speak in Tamil. Trust me, I go to West Bengal, they speak in Bengali. They speak in Kannada. They speak in their own language. Unfortunately, we have no respect for our Telugu point is concerned. But we have to protect it. Otherwise, what will happen? Over a period of time, especially now current generation verify, I'm sorry to make this statement, there are students today who can speak Telugu, but they can't read a newspaper. They can't write in Telugu. I'm sorry. This is my observation I have seen it. Many people can't write in Telugu properly. Many mistakes will be there. And what will happen after the 40-50 years? And people look at Telugu, what it is? That day will come. That's which is pathetic. Na? You have to safeguard your own language. Article 29. No citizen shall be denied admission into the educational institutions maintained by the state receiving the grant in aid, state funds on the ground of the religion, race, language, etc. etc. Government school, everybody got a right to get admission. SC, ST, BC, OBC, EBC, whatever. Everybody got a right to get admission there. You can't discriminate based on the caste, creed, color, religion, language, etc. etc. And Article 30 mentioned that right of the minorities to establish and administer the educational institution. Minority education institutions and government is permitted because they don't have the proper privilege and facilities outside. They want to promote their own culture and language. It is allowed. Education minority institutions were there. It is run by Trust Minority Funding Act. All minorities based on the religion and language shall have a right to establish and administer educational institutions of their own choice. We have every kind of a minority institutions are there, notice and outside. They have their admission will be there only for that community. Almost 98% that community will be there. Here and there 1-2% may be overlapping except reservations. For them advantage, tax liability is not there. Totally exempted from tax liability. In making of law providing for the compulsory acquisition of any property of an educational institution established or administered by minority referred above, the state shall ensure that amount fixed or determined by such law for the acquisition of such property would not restrict or abatage, nothing but cancel any guarantee under this clause. They can acquire any mobile or immovable property for educational institution. The state shall not, means the government cannot, grant in aid educational institutions discrimination against educational institutions on the ground that if the management of the minority based on the religion or a language. Even the minority institutions also can get a grant in aid if they are in a grant in aid positions. Law permits. Article 32, this is the last article. And Article 32 mentions about the right to constitutional remedies. I told you yesterday, if you remember, if the fundamental rights were not provided, go to Supreme Court, Article 32, go to High Court, Article 226. Fundamental rights is the primary responsibility of the state to provide. If the fundamental rights were deprived, I can file a case. Directive principles of the state policy, one chapter is there in the Constitution of India, that is not a primary responsibility of government. But fundamental rights are primary responsibility, government has to provide. If not, we can file a case against the government. Okay, right to life, freedom of speech, freedom of expression, or right of liberty. You can have fundamental rights are there. If any person deprived, you can file a case. Article 32 says something about this. Right to move to Supreme Court appropriate proceedings for the enforcement of the right conferred in the parties guaranteed. Whatever the fundamental rights are guaranteed, if they are deprived, I can go to Supreme Court. The Supreme Court shall have a power to issue the directions and orders and writs. We will discuss writs separately. Writs including writs of the nature of all these points I will explain. Habeas corpus, mandamus, prohibition, quaranto and cetera, and whichever is appropriate for the enforcement of any types of the referred in the part 1. And without prejudicing the powers conferred in the Supreme Court above 1 and 2, Parliament may empower any court or access within the local limits of the jurisdiction of all or any of its powers exercised by the Supreme Court. Right guaranteed by this article shall not suspend except otherwise provided by Constitution. Let us see what are the remember, you can file a case in High Court, Supreme Court. High Court means Article 226, Supreme Court means Article 32. You can move to Supreme Court. These two remember. Okay. Now please write. What is the meaning of writ? Writ means W-R-I-T. Writ. All these points, now I am going to give the meaning. Habeas corpus, mandamus, prohibition, quaranto and all. Writ means written orders that are given by either Supreme Court or High Court. Orders given by either Supreme Court or High Court. Under that you write first one, habeas corpus. See here, this is the word. Habeas corpus. Habeas, red ink marker first one. Habeas corpus. Habeas corpus means, write down, to have the body of it is used for when unlawful detention has occurred. Unlawful detention has occurred. No. So first one is habeas corpus. Habeas corpus means one person was arrested by the police. Where the person is, they are not giving information. Unlawful detention. Before you arrest, reason you have to state. Reason, either reason was given, which police station he is in, you are not giving information. Generally, from the date of arrest, within the 24 hours must be produced before the court end. That's a rule. Any person arrested, within 24 hours he has to produce before the court. He was not produced. Where he is, no one knows. The relatives are worrying about, family members are worrying about. They can go to court, Supreme Court or High Court, praying the court. Habeas corpus means that the person body should be presented, whether alive or dead. If the court is satisfied with the argument made, they will direct the police department, produce the person. They have to bring it. They have to bring the person. This is a violation of law. All legislative, executory and judicial. Judicial powers are supreme powers. Whatever the judiciary said, executive person has to do. No, they can't say no. And that's a habeas corpus means produce that body. Because that person is missing, arrested, unlawful detention, produce. Second one, mandamus. Mandamus corpus. Mandamus, very simple. Mandamus you write. Mandamus means we command. Mandamus means we command. when a public official or body or corporation or lower court or tribunal or even government has not done the needed duty or refused to do after this writ is issued the duty needs to be resumed. Verify. I repeat. Mandamus means we command when a public official, body means any kind of a company, corporation or lower court, tribunal, even the government, maybe state government, central government, local government, has not done needed duty or refused to do. After this writ is issued, the duty needs to be resumed. As a collector, you have to distribute the vacant land to the needy and poor people. You are not distributing. Means deliberately collector is not discharging his duty. Somebody can go to court, mandamus. Land is there, he is not discharging his duty. Despite a repeated request was made. These are our requests. Produce evidence. Then court will order. Do this. Immediately district collector has to distribute it. The orders may be applicable to either government, company, corporation, tribunal, even central government, state government. Sometimes the court ordered government, pay this compensation to so and so. Direction was given. It was not followed. Then again they can go to court. Orders were given, but government was not paid money. Then mandamus writ petition they have to file. Then court will examine the case and order the government pay with immediate effect. Otherwise, arrest the concerned official. So it is a remark on public. Retirement benefits they won't get in case if they are arrested. So they need to perform this mandamus. Third one, prohibition. Third one, verify. Prohibition. Prohibition means to forbid. F-O-R-B-I-D. To forbid. Continue. This is used when a court which is in lower position that is lower court exceeds its jurisdiction. Lower court exceeds its jurisdiction. So prohibition is nothing but a to forbid. For every court there are some limitations and certain cases you can't handle directly. Case pertaining to upper court. How can you admit that case first of all? Prohibit. And in case the case was admitted and beyond authority if the court was acting, they can give a direction to the lower court, don't do all this. Stop it, you are exceeding your power. Ultra virus, invalid na? And stop the proceedings, ask them to appeal to next level of the court. That is prohibition, right? When the court was acting, exceeding its power. Next, third one, fourth one, Co-warranton, quo-warranto. See on the screen. Quo-warranto means by what authority or warrant when an illegal issue, right? Illegal, USURATION, of a public office by a person is done. Co-warranto is nothing but someone is illegally occupied the office of the government. Means you have no authority to occupy, you don't have qualification and all, but still you occupy the office and wanted to run. Then you can go to court, co-warranto can be issued. Last one there. Last one, this is certiorari. Means to be certified or informed, lack of judicial error of law. Error, ERROR, judicial lack of error of judicial error of law. I repeat, to be certified or informed, lack of judicial error of law, which means if there is any mistake in the law, that can be bring to the notice of the court. This was the blunder they have committed while drafting the skill. It has to be corrected and it will be done accordingly. That is the co-warranto. That's all. Next one, guys. Sources of law. Reads the point of view, maybe meaning you remember. Short answer, I mean MCQ questions important. Sometimes essay type question also. Different types of the writs explain. 7 marks, 8 marks questions are there. There all those points are important. Meaning is there. That meaning just you write one by one. Enough. But if I. Okay. Now see the next one. What are the sources of law? If you remember day 1 Contract Act, when we started, I gave some clues almost similar. And now in detail we are going to learn it. See the points though. What are the sources of law? First one is the custom. Second one is judicial precedent. Precedent means court judgment. Third one is legislation, legally. So these are the 3 major sources for development of law. Custom. What is the custom? As a Hindu, we have certain customs. As a Muslim, you have certain custom. As a Christian, you have certain customs to be followed. The custom is a major source of law. If you remember day 1 contract law, we have done such a way. What are the sources of law? British law. Then I said custom. Then I said third one, internal environment and external environment, parliament. Parliament means legislation. So various sources are there. Custom is the major source for development of law. No law goes against the customs and traditions of the persons residing. How do you say this is the valid custom? How can you say that this is the valid custom? In order to say this is the valid custom, there are first one, antiquity. In order to say this custom is there, means antiquity means this word you remember. Since the time is immemorial. From when this custom started, no one knows. Generations were following the same, and we are also following the same. Why means we have no questioning on that. We won't ask also. For example, marriage, rituals are there, custom. In case of death of a husband, some rituals are there, custom. And the custom should be when we are following, no one knows. And if you ask our grandfather, I don't know, my father said. He will say, my father said. He said, my father said. It goes on like that only. Means there is no time limit. Since last 2 years or 10 years or 5 years or 100 years or we are following, there is no time. That's why this is always antiquity. Means time is immemorial. Since long we are using it, it become part and parcel of our custom. Nothing but a family customs. And generally after marriage is solemnized, immediately people go to Tirupati. I don't know how many of you knew this. Immediately, on the very next day, people travel to Tirupati and they have a darshan and come back. Why means people say we want to go for honeymoon. Still, Baba, first to go to temple. Why means they also don't have much reasoning on that. Some customs and we don't have reasons. And people say only thing, since our forefathers followed, we are also following. That's it. Sometimes we can get an argument on that, nothing but a reasonable answer will get. Sometimes they say, I don't know, they said, they did, I am also doing the same. No answer for it. Won't get a proper clues. Custom. So since long following, we are also following. And second one, continuous. Continuous means no interruption. Custom once started following, once for all following, there is no break in between. If breaks are there, it won't become custom. Like once there was a sati. Sati, when husband died, wife also died. And people fought for this, this is not correct. And that was discontinued. Can again start now again sati? Will it become custom? No. It won't become custom because already there was some interruption. Custom should be followed uninterrupted manner. Then only this is going to be a custom. While marriage, people say that a Mangal Sutra has to be tied for 3 times. Why 3 times means? People will argue, and by seeing the stupid movies, people will question many things. Without yellow thread, what will happen? Nothing will happen. What will happen means what we can say. Our customs are there, traditions are there. We have to do certain things. We have to follow, man. Nothing wrong in that, which is good. And it will discriminate married and unmarried. People say, I won't wear the rings for the. If you wear the rings, identification that she got married. The respect will be there for you. By looking at a girl who got married, people got some kind of respect. At least some people will be very decently behave with that woman. Isn't it? The purpose is there, yeah. People won't understand. And people always say that why means this generation is questioning. And earlier people never used to question anything. Why? Amma says today, wear the bangles up to here. No. Here one, here one. That too Mangal Sutra 24/7 earlier people used to wear. Now people, when festival is there, they will wear, otherwise they hang on there. Who is the husband, who is the wife there? I can't understand. No, just imagine here. You are removing and have hang on there means custom you are discontinuing. A later part of the day people say, no problem, without that also people are moving here and there nowadays. No Mangal Sutra, people are coming out and doing the many things. Of course, I don't know. Continuity. Only thing is no interruption. What I am trying to say. Continuous practice and disinterrupted and long intervals must not be there. Any kind of a custom. And reasonableness. Custom should be reasonable here. It must not create any harm to the society. Morality opposed to public policy must not be there. This is nothing but a custom is like a more inconvenience or mischief than convenience, then custom will not be valid. Any custom which is creating a convenience, accept it. Which is inconvenient and creating some mischief on the general public, that is not a custom, discontinue. Best example, untouchability is not a custom. Discontinue. Sati is not a valid one. Inconvenience. Why husband, why should she die? What is the reason? What is the logic back of it? I can't understand. When she was born, he was not there. Journey had joined in the life. Suddenly that fellow died. How can you say that you also die? Hello? ये क्या बात कर रहे भाई? In between, many people come and go in the life here. It's like a journey. And how can you say that people, husband died, you also die? So tomorrow, why not a wife died, husband died? Why people won't speak that way? Quite opposite is not there, no? Why can't? like that. Other one is morality. Custom is a immoral or custom which is immoral opposed to public policy cannot be valid custom. And court declares many customs are valid and practice is immoral purposes. You can't practice anything which is, I don't know, there is a one culture earlier, one custom was there, Devadasi. Have you heard this word anytime? One woman was confined to, she will marry the god and she will stay in the same temple. Very, very unfortunate culture ending. The elder person of that family, nothing but a temple or anyone, abuse that lady. Devadasi culture, originally good culture. That's why she admire the god, she marry the god, and she lives for the sake of God. And the later part of people started abusing that woman. And later that culture was discontinued. That was not, which is immoral, against values of the dignity of a woman was not protected there. Thereby 4 conditions. This question important. Custom point of view, please remember. Okay, na? Now, how many types of customs are there? General custom. What are the general custom? Customs prevailing throughout the territory or the country. Entire country this is there. Not at one particular place. And other one is local custom. These are there only a part of the state or a particular religion of the country. Some people are there. Seeing the boy and a girl before marriage is an offense. They can't see each other. Some cultures are there. Tribal area, when you go, they can't see each other. After marriage only they will see each other. In Hindu culture also it is, they can keep one curtain between the wife and would be bride and bridegroom, if you see. That culture is there, but our people well in advance knowing to each other nowadays, before marriage only they are completing what we call reception. Marriage at 0 hours, because our guests and dignitaries want to stay, first they conduct the reception as if married, and photographs and all. And at the late hours, marriage will happen. We are going against our customs and traditions, man. Follow. We are going for marriage, for dinner or photographer. First decide. Then don't go. If you want to see the marriage, go for marriage, man. You are saying that I am going to attend a marriage. Nobody will see marriage and they can't understand. Hardly some relatives will be there who are keenly noticing and making some comment on that. Otherwise, busy people are busy otherwise. Okay. Local customs and conventional custom. Conventional customs are binding the parties to the agreement. Nothing but a trade or business. Business people can have their own customs and traditions. For their convenience of the business they have drafted. Since the time is immemorial, people were following the same customs and traditions. Business go with the trust and people do the agreements according to customs and traditions which they have developed. 3 types of customs. So this is the custom point of view, first point. Next one is judicial pronouncement. It is the major source of land, which means one court gave the judgment. We know the facts and figures of the case. Tomorrow, if the similar case has come, same judgment is applicable. That become the source of law. Sometime they develop the various other sources of law. Best example, in India, Domestic Violence Act, day by day atrocities against women is increasing. Then judgment has come. Women's rights shall be protected, so that government has to look into the women's rights and prepare the domestic violence law. Since one judge gave the judgment, Domestic Violence Act came into force in India. Court judgments also sometimes precedents will be considered with a view to make the laws and source of law for developing the various systems. Till yesterday it was not there, but now onwards it will prevail. It become a law. Judgment will prevail. If you do remember, now right now one case which is happening, whether 17A is applicable to Chandrababu Naidu or not. When it is applicable to Bommai, who was the former chief minister, why not applicable to former chief minister of another person? See, since long, case is going on, trial is going on. See how many things were happening. And immediate judgment has to come, people are dragging the case for a long time. And yesterday, if you remember, see the newspaper, I was reading one of the Supreme Court former Chief Justice, he was saying that somewhere something is not correct in the system. And within the 30 days maximum, a person can be put back off the bars. Later, you have to give the bail. Because case was not proved against a person. You were not failed to file any kind of documentary evidences against him. Then release him on the bail. He got a right. But unfortunately, our people, once he was the advocate again for the Sisodia, there, the Delhi liquor case is concerned, almost more than 6-7 months he was back off the bar side. What is happening? No one knows in India. Judiciary system, people are slowly maybe managing, manipulating, I can't speak that word, but generally see, which is not a right precedent. This is not a right way. This something is not correct. Tomorrow, if that is the case, everybody will be arrested, put back off the bus for 6 months or 8 months or 1 year, 2 years without bail, isn't it? This is not a correct sign. There should be proper argumentations on that. So, court precedents are there. Remember, Supreme Court, High Court and Lower Court. Remember, whatever order passed by the Supreme Court, all High Courts, Lower Courts must and should have to follow. The order passed by High Court, one High Court order was passed. Other High Court can be considered that as a base for giving the judgment. Second one. Andhra Pradesh High Court gave one judgment. Similar case come before the Tamil Nadu High Court. That case judgment can be referred, can get a justification. Law permits it. And lower court judgment can be prevailed. For example, lower court gave the judgment, I am not satisfied. I can go to High Court. High Court also supported the lower court. I can go to Supreme Court. Supreme Court said lower court judgment was fair enough. Follow. Sometime I walk in directly to Supreme Court. What Supreme Court says? Follow the order. Go to lower court. Go to lower court first, where you have to file a case. If you are not justified, then come to upper court. We are there for you, undoubtedly. We will safeguard your interest. Directly don't come here. Nothing but a supersede all the procedures. Don't do that. Go to lower court first. See what they say. Then go to High Court. Then you come to Supreme Court. Otherwise, everybody directly walk into Supreme Court only. Isn't it? You should not supersede it. And Supreme Court judicial authority and streamlined system of the court was established. Supreme Court binding all courts in India and not bound by its own decisions of the Privacy Council and Federal Court. Let me explain here one point. I think I told you, single judge judgment can be challenged before the bench, nothing but a division bench. The division bench judgment can be challenged before full bench. First case go before the single judge. Single judge gave the judgment. I am not satisfied. The single judge judgment I can challenge before division bench. Means 2 or more judges. Same court. The division bench judgment also I am not convinced. Then I can go to full bench. Full bench means 4 or more. 4 or more. 3 or 4 or more requirement. Ayodhya case, 9 judges were there. 9 judges. Full bench. Supreme Court appointed judges. Look into the special case and give it the judgment like that. And the High Court binding all courts within its jurisdiction. It is a pervasive value for the court outside in the jurisdiction. In case of conflict of the decision of the same court, the bench of the equal strength refer to the higher bench. Nothing but one High Court judge gave the judgment. His judgment can be challenged before division bench. That's the point. Single judge judgment, I am not satisfied. Agreed person. One person happy, other one not happy. I can file before bench, division bench. That's the point. And decision of the Privy Council, Federal Court, binding as long as they don't conflict with the decisions of the Supreme Court. In India, paramount importance decisions are nothing but a paramount peak. Apex court is always Supreme Court. The Supreme Court also single judge, division bench as well as full bench. Three areas are there. Full bench decision is final. There is no further appeal there. Parties need to follow. Lower court bound to follow decisions of the higher court on its own state. Means in Andhra Pradesh or Telangana, lower courts are there. District court to magistrate court to, right? They will all follow the decisions passed by the High Court. High Court is the final decision. Tomorrow, Andhra Pradesh High Court gave the judgment in favor of the Chandrababu Naidu. Then the CB Court, nothing but a ACB Court should follow directions given by the High Court. High Court, whatever said, lower court has to follow. And it is proceeding in preference to the High Court and other states. And these are all next 2 points are there. Ratio residendi. Judicial decisions to be divided into ratio decidendi. Ratio decidendi refers to the binding part of the judgment. Ratio decidendi initially means the reasons for the decision. It is considered as the general principle which is deduced by the court from the facts of a particular case. It becomes generally binding on the lower court in future cases involving the similar questions of the law. Lower court gave one judgment based on the facts and figures. Upper court gave one judgment based on the facts and figures. If the similar case comes tomorrow, same rule is applicable. No further reference, no further argument. That is called first one. Second one, Aptiker dicta, which means it refers to the part of the judicial decision which are general observation of the judge, do not have binding authority. See the line carefully. Two parts of the judicial decision which are general observation of the judge do not have the binding authority. However, Aptiker of the higher judiciary is given due to the consideration by the lower court and pervasive value, having considered the various aspects of the precedent, that is the ratio. Aptiker cleared the system of the precedent based on the hierarchy of the court. Nothing but a lower court gave the judgment. It can be challenged in upper court. Upper court after considering the facts and figures but not a general consideration. Lower court judge was considered the general observation. With the general observation he passed one order. Nothing but a natural justice, one concept is there. Based on the natural justice he gave one judgment. Challenger before upper court and upper court gave the judgment considering the facts and figures. No general observation here, only evidences based on that judgment can be given. And now what are the sources of law? Here legislation. 2 points completed. First one is custom, second one is the precedent, and third one is legislation. Legislations are 2 types: primary legislation, secondary legislation. What is the primary legislation? A primary legislation means a law passed at Parliament. Laws passed at Parliament or the state. State means here maybe central government or state government. And how the laws are made at a Parliament procedure is there. We will discuss in the next chapter. There is a very lengthy procedure is there. I will explain. Okay. The primary law which is passed at a Parliament or a state level. Second one is secondary law or subordinate law. This is called secondary law or subordinate law. Based on the primary law, subordinate laws can be made. Delegated powers are there. We delegate authority to local government, state government to frame their own rules and regulations. To understand, I give you one simple example. Cooperative Societies Act 1912, applicable to entire country. But a cooperative concept is there in the third schedule. What is the third? List 3. What is the list 3? Concurrent list, where central government to state government can frame the rules. Now central government framed the rule. Now state governments were empowered to frame their own rules for the cooperative society's point of view. Delegated authority. That delegation of authority to frame your own law in your respective state is called subordinate law. Secondary law. The primary law was made by central government. The secondary laws were made by the state governments, local governments. They can frame their own law, but that delegation of authority is there. The central government is delegated authority to state government delegated authority to local government. With the delegated power, if you have passed any legislation, that is called as a, what you call it as a subordinate law. Do remember, sir, very important, these two laws please in examination. Amendment 73-74 of the Constitution of India has given authorization to frame the rules for a panchayat. Gram Panchayat, municipality elections were there. Municipal laws, each state municipal law is different. And Gram Panchayat rules you can frame according to your own requirements. That way. Let us see these words. The primary law, of course here words remember, true or false purpose, fill in the blanks purpose. The word term legislation derived from the word legacies, which means law. Lactam, which means to make or set. And the legislation means the making of law. And now what are the laws here? Primary law, when the laws are directly enacted by the citizen and nothing but a central government, is called as the supreme law. And one of the feature of the supreme law is that no authority except the citizen itself control or check it. The law enacted by the British Parliament is the full category of this one. The British Parliament is considered as the citizen. According to India, Indian Parliament falls in the same category. In India, the power of the Parliament to regulated and controlled by the Constitution through its enacted by laws, and hence it is called legal body. So in India, Government of India, whatever the rules are framed, they are called as a primary laws. In England, British law, whatever the law Parliament, British Parliament made, that's called primary law. Okay. And what is the subordinate laws? In case of a subordinate law, legislation which is made by authority, which is subordinate to supreme or citizen authority, it is enacted under the delegated authority of the citizen. Origin, validity, existence, continuance of legislation totally depends upon the will of the citizen authority. The subordinate legislation further classified into as follows. First one, local laws. In case of a local law, some countries, local bodies recognized and conferred by law-making powers, they are entitled to make bylaws for their respective jurisdictions. In India, the local bodies like a panchayat and the municipal corporations has been recognized by a constitution through 73-74 constitutional amendments. The rules and bylaws enacted by them, example for the local laws. Municipal laws are there. Andhra Pradesh Municipal Act, Tamil Nadu, Telangana Municipal Act, separate laws were framed for their purposes and accordingly. Law made by executive, these are the supposed to be executed by, laws are supposed to be enacted by citizen, and citizenity may be the vested in the one authority, or it may be distributed among the various organs of the state. The most of the modern states, citizen is generally divided into among the three organs of the state. Those three organs are nothing but a legislature, executive, judiciary. Legislations were made by parliament, executed by central government, state government, and the legislature purpose is giving interpretation of the law. Wherever necessary, whenever necessary, how to frame the recent amendments according to change of the public. According to change, we have to change our laws also. Law will give the suggestion for that end. So laws were three areas, remember: legislature, same parts are explained here. Three different stages. The primary responsibility of the law making vests in the hands of the legislature. The executive is vested with the responsibility to implement the legislature, and the legislature delegates some of its non-making powers executive organs which are termed as the delegated legislation. The delegated legislation also called subordinate legislation. The welfare and modern states among the various has been increased the manifold and not possible for the legislative body to go through all the details of the law. Therefore, it deals with only fundamental part of the legislation, and wide discretion has been given to executive for all these gaps. And this interestingly increasing tendency of the delegated powers, delegated legislation has been criticized. However, delegated legislation is resorted to and amount of the reasons like a paucity of the time and technicalities of the law, emergency. Therefore, delegated legislation sometimes considered as the necessary evil, because each state social conditions, demographic environment is something differently there. Each state shall be allowed to frame their own rules and regulations. So, primary law, central government will frame. Delegated powers to state government, local government to frame the law, subordinate law. To execute this one, three sources: legislative, executive and judiciary. Legislative means framing the law, executive means implementation of law, and judiciary means interpreting the law. According to change in the environment, we have to change the law, bring the new amendments. Same points were repeated in the next chapter also. Primary law, secondary law, verify. These are the only content was repeated second time. Primary law and secondary legislations. Nothing new is there here. You go through once, you will understand. Same points were given, copy pasted. Okay, na? At home, just give one reading on this one. If I want to quickly read out, you will get the points. Fatafat. Just you read primary law, secondary law. Same points are there here. That's it. There is no much difference. Maybe adding the 2-3 lines more extra. That's it. Purpose is the same. That's it. Primary legislation, subordinate legislation, delegated legislation, delegated powers to ancillary, not here 4 pillars he gave. One more word they will add present. See here, legislature, executive, judiciary and press. 4 pillars of the Indian democracy. These 4. Press also. Nowadays the press become biased, and originally press should be impartial. It's a powerful weapon where you can communicate exact information to the society. Unfortunately, each press, nothing but electronic media, print media, owned by political parties, and they become their pamphlets. And exact information we don't know what is originally. So that we are in a dilemma, what is to believe, what is not to believe. Trust me, confusion will come. Yeah, always confusion. Whom do we trust? With especially social media, a lot of confusions are there. Okay, at home, please read these points. Now guys, the legislative procedures in India. How laws are made in India? Listen carefully. I am giving the summary and here. How laws are made. This is the entire summary. Later part I will read out. First to understand. I think I told this point also in the beginning itself. How laws are made in India? Parliament, primary law. First of all, concerned ministry. Nothing but we have the 20 to 25 ministers are there at cabinet level. Each ministry, one portfolio. It may be agriculture, industry, finance, law and order, different. They are leading the portfolios. One minister felt, in my department, we need to have certain issues are there, we have to tackle it. We need separate law to handle these issues. So first of all, ministry must identify the issues, problems involved in a particular area. First, identify the problem. Second, draft one copy. What was the problem you are facing? What solution you are expecting? You draft one copy. That copy sent to Cabinet Secretary. Copy you have to send to Cabinet Secretary. Cabinet Secretary of that ministry will examine, forward that copy to Minister for Law and Justice. Minister for Law and Justice, we have to forward one copy. Those people, after considering the problem, if there is a genuinity, they will ask the concerned minister, draft one bill on this and submit to us. So those people will draft, the concerned minister will draft, minister means department, will draft one bill, nothing but what are the requirements of law. That copy forwarded to Cabinet Minister as well as Cabinet Secretary. One copy they will keep on a public domain for 30 days. Public domain, what is the purpose? Different people will access that information. This is going to be the new legislation, and if they want to give any suggestion, they can give 30 days time. And various departments like a CA, CMA, CS, management associations are there. Copy is forwarded. They will conduct seminars, workshops, and what are the pros and cons from macro to micro level. They will review. They give recommendations to government. After considering the recommendations given by the different section of the people in the society, our drafted bill with the recommendations, that copy forwarded to Minister Law and Justice. That fellow final draft will be prepared. From the law department, no objection has come. Nothing but can I pass this act or not? Constitution shall not prohibit. So that they have to see the constitutional viability. Yes, allowed. Law department was not objected. Bill was ready, and report is sent to Cabinet Secretary. What is the purpose of Cabinet Secretary? Every time that bill will be there, in the bill name shall be included in the cabinet meeting. Before the bill present into Parliament, it should be placed before the cabinet meeting. In the cabinet meeting, agenda will be there. In agenda, this item should be there. In cabinet meeting, some discussion will go on. All members and Prime Minister said, go ahead, approved. Then that bill is moved into House. Some debate will happen on that. Meaningful dialogue shall be there. And what is the need of this bill? The minister will support. Why do they want to introduce this legislation? And opposition leaders and ruling leaders got every right to participate in discussion. Anything to add, anything to delete, they can do it. At the end, members have to accept with voting or polling. If they are accepted, bill is approved. It should be approved both the houses. First move it to the Lok Sabha, then move it to the Rajya Sabha. Once the bill is approved, that copy is sent to President. President give the consent, then notify. Notification is nothing but a gazette. Gazette notification. Official gazette notification. Gazette notification, central government. Official gazette notification, state government. That is called Rajapatra. Means finally the act came into force. They will give the effective date. These are all steps. Sometime the bill presented, members got a disagreement over the bill. One house accepted, other house rejected. Then joint committee meeting will be conducted. Nothing but a joint house meeting. Means members of the Lok Sabha, members of the Rajya Sabha, all meet at one time. Very exceptional cases it will happen. And all will sit and discuss how it should be handled. And finally approved, send a copy to President, get an approval. In case bill not approved by members, were lot of objections were there, then bill was sent to review committee. Bill was presented, some are agreeing, some are not agreeing, majority people got objections on that. Then do one thing, it will be sent to review committee, nothing but a select committee. The select committee consists of again members of the ruling party as well as members from opposition party. All will sit and discuss the issues, what are their objections and what is the solution for it. Everything will be drafted, present before the house. If members agree and possibility changes are there, again bill will be moved into the parliament, and with the consent president is agreed, legislation came into force. Orally looks very simple procedure, but it will take its own time, not easy. Everywhere lobbying is required. Example I would say, only for understanding. AP Reorganization Act. This state is demanding AP reorganization. Since 60 years, people were demanding, we want a separate state for Telangana. And finally, problem was identified by the Home Department. Home Department means law and order issues are coming here. That's why Home Department identified. Then they prepared one note, sent it to the Cabinet Secretary. Of course, before that they have to discuss with the Prime Minister. That's why something official, something unofficial. Officially many things will be there, unofficially maximum will happen. First Prime Minister approved, then only everything will happen. Copy note has to be sent, and Prime Minister said, go ahead. Agreed. Then war footing manner, bill was drafted and Article 3 was amended and permission was granted. Fatafat war footing basis. And everything was approved, cabinet approval was there. And bill was drafted. Who drafted the AP reorganization bill? Jairam Ramesh. He drafted the bill for AP reorganization. Many mistakes were there in that. And people know very well all those things. And that's such an intellectual person drafted. Still mistakes were there. And he drafted the bill. Law Department gave the clarity. House presented. And Lok Sabha, all the doors and windows live to close. Live telecast was closed. Within 15 minutes bill was approved. Who approved? No one knows. At the end, Rajya Sabha people said approved. Then President signed, state formed. They said notify June 2nd onwards, separate state. Notification. Women reservation bill is there. Women reservation bill, 33% reservation. Narendra Modi dream. He want to gain some kind of polarization of the votes of the women probably. That too, execution from where? Not from 24 elections. Hello. Execution from 29 elections. If that is the case, why bill has to be passed now? You can understand the intention of the government. And thereby anything is a problem. That's why identify the problem. Bill has to be drafted. Law Ministry must not have an objection. Constitution must permit. Bill is prepared into public domain for 30 days. Then bill presented with a needful modification, cabinet meeting approval, present into the parliament, parliament approval both the houses, president consent and notification for effective date. At a nutshell, all these points. This is how laws are made at a central level. State level also same. Only delete the change the vocabulary. In place of president, write the word governor. That's it. Okay. Let us see. Every country governed by set of the rules and laws. Importance of the law ancillary rules is maintained some balance in order of the society to regulate the behavior of the various entities within. Every decision, I don't think first point is not so paragraph. We go with the second paragraph. And the constitution never override the any of institutions in India. Government of India has many ministers but cater the various sectors that are in change of putting the fourth proposal involving the major policies that of the national importance. The major policy proposals usually in the line with the goals of the government that gets elected to the power. Therefore, the bill is produced at the parliament and a detailed study, survey is undertaken by the relevant ministry and its ancillary departments. The study relating to the social financial cost, benefit and key challenges that required to be settled before and after the legislation came into force. AP reorganization means Telangana is getting benefited, AP is at loss. Then there may be unrest, law and order problem may come in that state. Then what are the steps to be taken with a view to safeguard that handling this scenario? Different stages the law goes through before it's get passed and acquired binding effect. Pre-drafting stage means before the bill is prepared. Pre-drafting stage. First comes to the formulation of the legislative proposal. The proposal has to come from the minister. The concerned ministry makes a legislative proposal only after consulting with the interested and effective stakeholders from the financial and administrative point of view, and concerned ministry also mentions the necessity of the legislation and proposal for the incidental matters. Pre-legislative consultation policy was adopted in pursuant of the decision committee headed by Cabinet Secretary on 10th January 2024. This is not necessary. And since that time onwards, Cabinet Secretary approval is necessary. Prior to that, it was not there. In this, concerned ministry department will have to publish the proposed legislation and with explanatory note either on the internet or through other means. The details will be kept in a public domain at least for 30 days. A piece of the legislation after a particular group of the people, it has to be published manner as it reaches that affected group of a people. The feedback with the stakeholder then taken into consideration while drafting the bill. And concerned ministry then refer the matter to the Ministry of Law and Justice for advice, particularly the legal and constitutional point of view. Ministry of Law and Justice at the point only advise about the necessity and desirability of the legislation in the light of existing law and constitutional validity of the proposal without going into the merits. Means whether this legislation is useful or not useful, you won't see whether constitution permits or not. Yes, constitution permits. Go ahead. What are the repercussions of the law? We are not addressing on that. After a aforementioned consultation, the concerned ministry sends all the relevant documents to the Ministry of Law and Justice with a memorandum. Law and Justice Department, Legislative Department prepares the bill drafted receipt of the proposal after getting the clearance from the Department of the Legal Affairs. Bill has to be prepared, and one draft copy prepared Minister Law will be, and it is accepted after scrutiny done by the concerned ministry. Note to the Cabinet Ministry sent for placing of the drafted before the Cabinet for consideration and subsequent approval. Remember, without Cabinet meeting approval, it is not going to be discussed at House. And after the approval of the draft, the concerned minister, the decisions of the Cabinet Ministry, necessary changes suggested which would be sent to the Ministry of Law. Any amendments needed, that will be considered by them, and Cabinet for making of such changes. After the approval of the draft, if no suggestion is given by the Cabinet, then the concerned ministry makes a statement, objective and reason relating to the bill to be signed by Ministry of the Law and Justice. To enable the Ministry of the Parliamentary Affairs draw the legislative program of the session and complete the details of the bill proposed for introducing during the session will be sent at least 1 month before the commencement of the session. Parliament will call before 1 month only. This bill has to be already presented at the House, and it has to be supplemented to all the members of the House. They have to read and come back. Then and there you can't give a bill and come and discuss on that. They need to have some time. They should consult their own legal persons. They come with the suggestions as such. And Article 109 read with 1010(1), 1171 of Constitution of India. Money bill is to be introduced first in the House of the People, Lok Sabha. Money bill, remember this, fill in the blanks important, or MCQ question. Money bill, nothing but a budget sign. Money bill has to be produced only in Lok Sabha first, can't in the Rajya Sabha. And in case of any other bill, the House which may have the introduction with decided by the consultation with the Ministry of a particular parliamentary affair. Except money bill, any bill can be presented either in Lok Sabha or in Rajya Sabha, up to you. After the Narendra Modi became the Prime Minister, he was introducing the bills first in Rajya Sabha, because Rajya Sabha doesn't have the proper majority early days. So he wanted first support therefrom. If they agree, better Lok Sabha automatically will win. Sometime Lok Sabha he got succeeded. Rajya Sabha means it will go to the select committee again. So that he playing accordingly. But except money bill always first to go before Lok Sabha. Okay. 107 provisions for introduction and passing of the bill. Subject to provisions of the Article 109, 117 respect of the money bill and any other finance bills, a bill may originate either of the House. Subject to provisions of Article 108 and 109, bill shall not be deemed to be passed by the House of the Parliament unless it is been agreed by both the Houses, either without amendment or with such amendments only as agreed by Houses. My proposal may be accepted as it is without any changes, or it may be accepted with the needful changes, means with the amendment or without amendment. A bill pending in a Parliament shall not lapse by reason of the program, nothing but a provoke. People say no, nothing but indefinitely this is postponed. 10 days to 15 days to 40 days sake, House was called. Within that House we failed to discuss. Does not mean that the bill is lapsed. The bill will be pending. It can be discussed in the next session. If this session time is the constraint, we are unable to discuss. This will be continued same thing in the next parliament sessions. And a bill pending before the Council of the State shall not be passed by the House of the People, shall not lapse for the dissolution of the House of the People. Nothing but now elections are ahead in the month of May or June. May elections are there, not this one, May. Next to May, general elections were there. November, April, May elections will be there for us. During that time, the bill was there before the House in the month of March or April, budget sessions are there. In the meantime, House was dissolved because elections were there. Some bills were placed before the House for the discussion. Since the House is dissolved, the bills won't be dissolved. It will continue. In the next, whoever may be the government comes, it has to be discussed. It has to be approved. It has to be rejected otherwise, as you like. And the bill which is pending on the House of the People, nothing but a Lok Sabha, or which have been passed by the House of the People, Lok Sabha, is pending before the Council of the State, Rajya Sabha, subject to provisions of the 108, lapse the dissolution of the House of the House. Nothing but a Lok Sabha approved, and before the Rajya Sabha it was not approved. In the meantime, House got dissolved, which means it will automatically dissolve the bill also. Again, we have to draft it, resubmit for the sake of the discussion. 108, joint sitting of the both the houses. I told you whenever there is a conflict. If after the bill has been passed by one house and transmitted in other house, the bill was rejected by other house, the house have been finally disagree with the amendments made in the bill, or more than 6 months lapsed from the date of the reception of the bill by the other house without being passed by it, the President may, unless bill is lapsed by reason of dissolution of the House of the People, and notify the houses of the messages if they are sitting, and public inform notification if they are not sitting. His intention to summons to meet the joint sitting for the purpose of deliberating and voting on the bill. Which means what? If you are see the 3 points were there. First one is one house approved, other house not approved. One house approved, other house rejected. Second one, house was finally disagree with amendments, only few amendments were disagreed. Call for joint house, joint meeting. From the date of approval from the one house, placed before another house, within the 6 months the bill was not cleared. The president will ask the house, what is the reason? Otherwise, the cabinet minister will ask the both the houses, conduct a joint house session, discuss about this one and come with a solution on that. And except money bill, provided that nothing in this class shall apply to money bill. Money bill budget has to be approved and it has to be passed at any cost. And in revoking such a period of the 6 months referred above, no account shall be taken on the period of during the house referred above, and the clause shall be provoked or adjourned for the more than the 4 consecutive days. The president notified his intentions summons in the house to meet the joint sitting house. Neither the house proposed further the bill, but the president may at any time after the date of his notification summons the house to meet the joint sitting for the purpose of specifying the notification. If he does so, houses shall meet accordingly. And if the joint sitting of the 2 houses on the bill with such amendments, if any are if any as are agreed to joint sitting passed by the majority of the total members of the both the houses present and voting, shall be deemed to be proposed by the constitution and passed by both the houses, provided that joint sitting, if the bill having been passed by one house and has not been passed in another house, such amendments and returned to the house which is originated, and no amendment shall be proposed to the bill other than such amendments which were necessary for the delay in the passing of the bill. One house approved, other house not approved. Total 20 amendments were proposed, 15 amendments agreed, 5 amendments not agreed. So, excluding these 5 amendments, the remaining amendments can be passed, resolution can be moved on. And other one is, if the bill has been so passed and returned, only any such amendments further shall be proposed to the bill, and such other amendments are relevant to the matter with respect to the houses have been not agreed, and the decision of these pending amendments shall be admissible after this clause of the final. Whether to discuss or not this final, where there is a disagreement, they can ignore it on that. And joint sitting may be held this article and bill passed thereunder, notwithstanding that a dissolution of the House of the People intervened since the President notified and summons have been passed to the matter. Even the House is dissolved also, since the President was ordered and the bill has to be approved. And finally, this is the last clause, I believe. This is the last one. What is the time? Still time is there. I can complete these 2 points. I can complete this, remaining we'll see in the next class. Tomorrow we'll complete. Article 109. What is Article 109 in respect of the money bill? A money bill shall not be introduced in the House of the States after the money bill has been passed by the House of the People, shall be transmitted to the Council of the Ministers for the recommendations, and Council of the States shall within a period of the 14 days and from the date of the receipt of the bill return to the House of the People with its recommendations, and the House of the People thereupon either accept or reject all or any of recommendations of the Council of the State. Means what? Lok Sabha approved, sent to Lok Sabha, to Rajya Sabha money bill. The members will give some suggestions. Whether those suggestions may agreed, may not agreed. Once it is approved by, with the suggestions, the bill was sent back to Lok Sabha. The Lok Sabha members may consider their suggestions or they may pass the bill as it is. And if the House of the People accepts the recommendations of the Council of the State, money bill shall be deemed to have been passed by both the houses and amendment recommended by the Council of the State approved by people of the House. Recommendation given by the people of the Rajya Sabha and Lok Sabha people approved, which means amendments were approved and bill was passed. And the fourth one, if the House of the People does not accept the recommendations of the Council of the State, Rajya Sabha recommendations, Council Lok Sabha was not approved, the money bill deemed to have been passed by both the houses from the house where it has been passed from the people without any amendments recommended by the Council of the State. So, Rajya Sabha members, their decisions are only recommendatory, may approve, may not approve. Even if you approve also, legislation, money bill is going to pass. Even if you don't agree also, money bill is going to be passed. And finally, if the money bill passed by the houses of the people, transmitted by the Council of the State, that is at Rajya Sabha, it is the recommendation is not returned to the House of the People within the said 14 days shall be deemed to be passed by both the houses and expiration of the said period from which it is passed by both the houses. Lok Sabha sent a bill to Rajya Sabha. Within the 14 days you have to send back. If you haven't sent back means as if we have approved. Both the houses were approved, resolution can be passed. And the assent of the bill, President has to give the consent. That is Article 111. When bill has been passed by the House of the Parliament and it is presented to the President, and the President shall declare either his assent on the bill or that withholds the assent therefrom, accepting or not accepting. And provided that President may, as soon as possible after the presentation to him, the bill for assent, return the bill if it is not a money bill to the houses of the requesting them, they will reconsider the bill or any specified provision thereof or particular will consider the desirability of introducing of the such amendments as may be recommended. His message, when the bill is so returned, the house shall be reconsidered the bill accordingly. The bill is passed again by both the houses and with or without amendment presented to the President for consent. President shall not withheld assent therefrom. We presented the bill to President other than money bill. Approved, passed, presented, but he objections was raised. He raised the 4 or 5 changes in the bill. He recommended some recommendations. This has to be amended. That has come to the Parliament. Again, Lok Sabha. After considering those amendments, again, bill was redrafted, presented before the House, House approved, sent to him, signed, legislation passed. He made the recommendations, President made the recommendations of change, but Parliament was not willing to do the needful changes, means without amendment. Second time you resubmit for consent. If a second time also submitted the same bill, President cannot reject. He has to sign. That's why only one time you got a right to reject. Second time without any changes, same bill resubmitted. Stubborn. The minister was stubborn, government was stubborn. No, should approve. That's why see occasionally the before house or after the house, during the house, the prime minister, chief ministers will go and meet the governor, governor and the president. I don't know how many of you try to recollect. One hand session going on, our president or prime ministers will meet once. Why? Some bills are coming, sign. Otherwise, what is our difficulty? Tell me, we do the needful things. Thing is, with amendment, it can be passed. Even without amendment, resubmitted second time, you must approve it. And lastly, After the assent of the President, the concerned Minister for the Law and Justice, official Gazette Not India, extraordinary, and forward the copies to all the state governments for publication in their official Gazette. Get copies of the Act printed for the general public. So once a President is given, Gazette notification, state government, official Gazette notification will be issued, the legislations come into force. When you read this entire content, do one thing while reading, you read one paragraph and on that summary note 1-2 lines you only prepare. That will be handy rather reading the whole. You read one time, easy end. This is not big deal, right? So ADR is there and tomorrow mostly it will be done. It won't take much time. Here my role won't be there. These are like Latin maxim meanings are there. That's not my job. So maybe another tomorrow, maybe 1 hour class mostly. Sharp by 9.